Thank you all so much for joining us today. And to let folks know on Zoom, I will be monitoring the chat during our Q&A portion. So thank you for taking time away from the news today and joining us for this very special event. Not only is this a book talk, part of our faculty book talk series, but it's a conversation between colleagues who were once professor and students and now founding and successive faculty directors of our College of Law's Indigenous Peoples Law and Policy program. So it is truly an honor for me to introduce them today. I am Teresa Miguel Stearns. I'm an Associate Dean and Director of the Daniel F. Cracchiolo Law Library. My distinct pleasure to welcome you to this very special faculty book talk, co-sponsored by the Indigenous Peoples Law and Policy program and by our Native and Indigenous Law Students Association. We are here today with our featured author, Professor Keith Richotte, a citizen of the Turtle Mountain Band of Chippewa Indians, in conversation with Professor Rob Williams, a citizen of the Lumbee Tribe of North Carolina, to discuss Professor Richotte's new book, The Worst Trickster Story Ever Told, Native America, the Supreme Court, and the U.S. Constitution. Professor Richotte is our new faculty director of the Indigenous Peoples Law and Policy program, as well as a professor of law here at the College of Law. Professor Richotte has published numerous books and articles focused on the intersections of race, law, sovereignty, constitutionalism, governance, critical race theory, intersectionality, and the Indigenous world. His second book, Federal Indian Law and Policy, is a textbook designed for those without a legal background to understand the legal landscape that shapes Native America. Those are my blue tabs that you see in that book. Our faculty uses this textbook, in fact, in the BA in Law and Masters of Legal Studies programs. Professor Richotte's first book, Claiming Turtle Mountain's Constitution, The History, Legacy, and Future of a Tribal Nation's Founding Documents, demonstrates the need to study the origins of tribal constitutions. A close study of the enactment of the first tribal constitution of the Turtle Mountain Band of Chippewa Indians reveals how the document created a legacy that continues to affect governance on the reservation today. Professor Richotte has served his tribal nation as an associate justice on the appellate court since 2009, and also serves as the Chief Justice of the appellate court of the Spirit Lake Nation. He received his JD and PhD from the University of Minnesota and his LLM from our Indigenous Peoples Law and Policy program here at the College of Law, under the mentorship of Professor Rob Williams. Professor Williams is a Regents Professor and the E. Thomas Sullivan Professor of Law. He is a graduate of Loyola College and Harvard Law School. He previously served as Chief Justice for the Court of Appeals of the Pasquayaki Tribe and as Justice for the Court of Appeals and Trial Judge Pro Tem for the Tohono O'odham Nation. Professor Williams is the author of multiple books, including the award-winning monograph, The American Indian and Western Legal Thought, The Discourses of Conquest, and a leading case book on federal Indian law. He received the Lawrence R. Baca Lifetime Achievement Award for Excellence in Federal Indian Law from the Federal Bar Association, Indian Law Section. He was also named the first Oneida Nation Visiting Professor of Law at Harvard Law School. Professor Williams has received multiple awards and major grants, federal as well as private, for the Indigenous Peoples Law and Policy program and his work. He has been interviewed by Bill Moyers and quoted on the front page of the New York Times, where he earlier this year published a lengthy op-ed entitled Kicking Native People Off Their Land is a Horrible Way to Save the Planet. Highly recommend it if you haven't read that yet. Professor Williams has represented tribal groups and members before the Inter-American Court of Human Rights, the Inter-American Commission on Human Rights, the United Nations Working Group on Indigenous Peoples, the United States Supreme Court, and the Supreme Court of Canada. Please join me in welcoming Professors Richotte and Williams today as we celebrate the publication of Professor Richotte's third book and welcome him back to the College of Law.
Thank you, Teresa, for that wonderful introduction, and thank you all for coming today, in person and virtually. It's a great turnout, and thank you, Keith, for writing this book. I really enjoyed it. I hope I get a hard copy when it comes out. So thank you very much. Your book is titled The Worst Trickster Story Ever Told: Native America, the Supreme Court, and the U.S. Constitution. Can you talk a little bit about the title? Who is this trickster fellow, for those who may not recognize him or her right off? And why is he telling us the worst story ever told?
Well, certainly. The trickster figure is a figure found in many different cultures around the world, actually. So it's somebody who is familiar to lots of different people, and certainly with native peoples as well, too. And we continue to see the reverberations of the trickster in the modern day, even though we don't necessarily recognize that. We'll talk more about that later. But the trickster is this really interesting character who, in these different societies and communities, who operates as a conduit between the supernatural and the real world, and the world in which we live. I shouldn't say the real world, the world in which we live. Right. So this trickster is somebody who is both divine, but also human as well too, and fits in both those worlds and can do amazing things. Can shapeshift, can change physical characteristics, but also has very real human emotions and things that they do. And so that the trickster is somebody who operates in both of those spaces. But in operating in both of those spaces, the trickster also very much shapes and changes both of those spaces. So, for example, the trickster is the reason why certain animals in the landscape have certain markings. Trickster is the reason why, say, birds fly the way that they do, right? The trickster is also the one who, in many different cultures, ends up stealing fire from the gods and bringing it to man, which fundamentally changes, again, both spaces, both the divine and the human. And so at the absolute bottom, the minimum thing that we could say that I want to communicate with this book about the trickster is the trickster is an agent of change. The trickster is somebody who creates and changes things, makes things new. And so then the innovation that we experience is very often the consequence of something that the trickster has done. And so that we still honor that spirit whenever we talk about somebody changing the game or breaking all the rules to make something better. So the trickster is somebody who changes things. And the worst trickster story is a story about how the Supreme Court has changed things in a fundamental way, but has done so without fully understanding or appreciating what that process is or what it does, or maybe possibly fully understanding and appreciating and not caring, or being very okay with what it is that the trickster, what the story is doing in the creating the change that it's creating.
Yeah, and you talk about the trickster occupying both spaces. What I thought was really unique about your book, and I've not seen it done anywhere else, is two spaces. Space one is sort of this native knowledge, native epistemology, a native wisdom, native storytelling tradition. And then sort of, really rigorous legal analysis of Supreme Court doctrine. And the book, I think, does a great job of occupying both spaces simultaneously. But maybe talk a little bit about that translation process and how you managed to develop a whole out of those two very different ways of seeing the world.
So what I wanted to do with this book was I wanted to examine that Supreme Court precedent through an Indigenous lens, right? Using the trickster figure and the trickster story as the mode of analysis. And to really think about this, not just with the lawyer brain that gets developed in law school and so on and so forth, but think about it as how it might be better understood in an Indigenous context. And the more that I looked at it, the more I was digging into this Supreme Court history and the doctrine, the more I realized that there was something going on here that was familiar when thinking through an Indigenous perspective. And the best way to understand it and to describe it was as a trickster story, as something that is trying to accomplish what a trickster story accomplishes by speaking to these moments of change, but done again in a way that is fundamentally misaligned with native epistemologies or understandings of the way the world should be, so that we get a story that cements in understanding the native peoples as lesser than as part of this natural world in which we all live.
And which you live too, because you come from a storytelling culture and people, and you have been educated in the white man's law. And so, you know, as I was reading the book, I was just thinking about your own personal background and again, the merging of those two spaces as both a Native American person steeped in their own culture and also steeped in the legal culture of the white world.
Well, yes, and so then the hope is that that perspective can give us a new perspective on this law, because the way the law operates is hierarchical and forces us to think through its own mechanisms. But if we take this step back and we reflect and we use the Trickster story as our lens of analysis, we can see it in a much different way, in a way that really reveals what's actually happening here. So that perhaps we can step back as scholars, as lawyers, as just people concerned with Native America, people concerned with American law, and ask ourselves, is this really the story that we want to tell?
Tell the story of the plenary power doctrine of Indian law, because I see that as one of the major stories that's going on in your book, on top of, beneath, and at the same time as the Trickster story.
Yeah, that is the worst Trickster story ever told, right? So it all started. I had a question for decades, right? And the fundamental question that I had, and that drives the book, is when did plenary power become constitutional? And so plenary power, for this audience, perhaps fairly familiar, but plenary power is basically just the federal government giving itself essentially unlimited authority over Native America. And we see plenary power in other parts of the law too, with immigration and with the law of the territories, right? But it's basically this unlimited power that is larger in scope than what we imagine the federal government being able to exercise over citizens. So then the question became, when did plenary power become constitutional? And the reason why that is a question is when this version of plenary power was first articulated in the 1880s, the Supreme Court explicitly rejected any constitutional basis for it. So we get a case, 1886 U.S. v. Kagama. It's really a case about the Major Crimes Act. And so Congress passes a statute that says, we, the federal government, have jurisdiction over major crimes as it concerns Native peoples against Native peoples on Native land, right? And so it's 1880s, the United States doesn't look like it looks like today. And so it's kind of like the United States suggesting that it has jurisdiction over Canada, Canadian citizens committing crimes in Canada. And so then the lawyers for the federal government, in trying to defend the Major Crimes Act, have to try to find some sort of hook in the Constitution to allow for this to be constitutional. And the thing that they come up with is the Commerce Clause, which is one of the few enumerated places where Native peoples are enumerated in the Constitution. And so, again, the Commerce Clause, we know what it has become in law school. In 5 minutes, you know what the Commerce Clause has become. But back then, it's a little different. And the court in Kagama said, well, no, we really don't buy this Commerce Clause argument for this criminal law statute. Which, when I teach the class in my courses, I make a big deal of it, right? It's big and dramatic. I slam the case book shut and I say, oh, phew, case is over, right? There's no constitutional basis for this law, and thus we can all go home. And then everybody looks at me like I'm an idiot because we know that the case goes on beyond that. And so essentially the court says in 1886 that it doesn't matter that we can't find this constitutional hook. Somebody has to have authority over these wild and crazy Indians, and it may as well be us. It may as well be the federal government. The states are the deadliest enemies. Okay. So what we get is we get plenary power, right? With no constitutional basis. The only real basis for this federal authority is racism. So then you fast forward, and these are the two cases that I bookend in the book. Is 2004, there's a case, U.S. v. Laura, in which the court says essentially, well, we have traditionally found the authority for plenary power in the Commerce Clause of the Constitution. So right away you can see that something's not matching up there, right? At first there's no authority, and now all of a sudden the court's saying, well, there's traditionally been this authority in the Commerce Clause. So then what the question that is pushing the book forward is, when did that change happen? when did we decide, when did American law decide that all of a sudden this thing that wasn't constitutional now is? So that's really what I frame it in the beginning of the book as a mystery, right? So it's almost like we start with this mystery novel and then work our way to where we end up.
It's interesting because there are Native American law scholars who argue that they can live with the plenary power. You know, the late Robert Lawrence actually titled an article, Learning to Live with the Plenary Power. And if you look at things like the Indian Child Welfare Act, that was an exercise of congressional plenary power, just upheld by the Roberts Court. You look at the Indian Gaming Regulatory Act, that's an exercise of congressional plenary power. You look at the hiring preferences that favor Indians in the BIA. You know, these scholars say, well, look, you know, you have to take the good with the bad, but we're probably better off, Indians are better off with the plenary power doctrine, regardless of whether it has a constitutional basis or not, than without it. How do you respond to those types of, arguments?
Well, those people are living in their moment, right? They're living in their moment in which the plenary power is not as terrible as it could be. But even a cursory examination of the history recognizes that the good has far outweighed the bad with this thing. And so then, as you well know, as I learned in the casebook that you authored, right, that we think of this as a pendulum swinging between different eras of policy in which the federal government on one side is trying to assimilate Native peoples, trying to destroy Native cultures, trying to eliminate Indians, right? We swing to another area where there's some separation or some distance, and there's not as much effort to try to destroy in these moments. Well, we happen to be right now in one of these moments where things are not that bad, certainly not as bad as they could have been. But if this pendulum keeps swinging like it does, and history tells us that it will swing again, right? We are going to go right back to an era eventually where plenary power is much more destructive than it is now. And even if it is not as horribly destructive as it has been in the era of allotment and termination and boarding schools and Indian police and all that kind of stuff, we're still hanging on to this idea to protect these vitally important things like the Indian Child Welfare Act, which, by the way, when you think about it, the Indian Child Welfare Act is not an expression of plenary power, but it is an expression of plenary power to try to rid us of the consequences of former expressions of plenary power. So instead of living with this big amorphous thing that is essentially unlimited, right? Even though we happen to be living in a good era, as it were, it's not always going to be that way. And so we need to think differently about what the possibilities are. So that would be my response.
So your research process for the Supreme Court side, the law side, is pretty rigorous. I mean, you clearly read a lot of the court's cases, that you've worked with them and studied them and written about them. I'm more interested in your research process for the Trickster stories, as they sort of appear and change and are there throughout the book. So I'm really interested in where does that come from, and how do you incorporate that in an authentic way, in your own voice, because you do write in your own voice. Describe that process.
Well, that's a very interesting question, because that was the area that I had to learn a little bit more about, right? I had focused my career on federal Indian law and the cases and the doctrine and what happened. So one of the things that I had to do is just do a lot of reading and a lot of thinking about what it meant to engage with tricksters and trickster stories, right? But I also realized at a certain point that if you were going to use the trickster and the trickster story as your mode of analysis, then this book could not be a typical academic book, that it had to function almost like a trickster story unto itself. And so that is a big part of the reason why it is written in my own voice, or written in a way that is not going to be familiar to somebody who's looking for a traditional academic text. And in fact, that's the reason why I chose Stanford as the press. I had a couple of other presses that were interested in the book as well, and I sent them the preface in the first chapter, and both of the editors were very nice and they were very kind, but both of them said essentially, oh, you know, this is good, but you're going to have to reshape it into a more traditional chapter that we expect out of an academic text. And that's my new, nope, that's not what I'm not going to do. But if you're going to use this mode of analysis, if we're going to ask folks to think differently about this body of law, and if we're going to indigenize this body of law, which is a call that we hear a lot of times when we're running in the circles that we run in, you're going to have to do it a little bit differently. You're going to have to think about it a little bit differently. You're going to have to allow yourself to speak in those terms through the trickster, with those trickster stories in a way that speaks to people in a manner that is not what they're going to expect with your traditional academic text.
Let's get back to plenary power, because we left off and you're saying, well, it's dangerous because the pendulum could swing at any moment. So let's say we get the ability, you're emperor of the world, to get rid of plenary power. What do you put in its place? What are the justices? What are lower courts? What are federal courts? What are tribal leaders going to use in place of plenary power?
Well, I'm a little bit afraid to answer that question because it's a real spoiler alert. I hope you see it by the book. But essentially, I think you need three things, right? The first thing that you need is you need to center the concept of consent, which is not necessarily a new call in Indian law, but something that is clearly fundamental. And frankly, it's not anything that should be too disruptive to how we think about governance generally, right? So if we think about, this is a bit of a 10th grade civics class explanation of it, right? But at its most fundamental, our theory of governance is based on this notion of consent, right? That the autonomous individual has ceded some of their own autonomy to the collective, right? And the collective government then protects what the autonomous individual retains, all of those rights, all of their access to property, so on and so forth, right? So the Constitution itself is a document founded on this understanding or concept of consent. That is central to just how we operate, okay, in our governmental structure. So you have to center that. The second thing, three things is what you need, okay?
I'm writing this down.
Okay, all right. Okay. That's good. It's chapter 5, too, if you're not writing it down. Okay. But the second thing that you need, right, is you need some sort of connection or hook to the Constitution itself. And so we can talk about the flaws of the Constitution. We can talk about its founding and who founded it and what that means for people who were not among those groups. But we are in a space where the Constitution operates as the center of governance. And so I don't necessarily think that you're going to convince Supreme Court justices to operate outside of the constitutional structure. So you need some sort of constitutional hook. The one that I found, the one that I argue is ultimately the treaty clause, which is there's a long story in how that all works and how it should work and how there's a misunderstanding of the treaty clause at present in the doctrine and how it operates to support, theoretically at this moment, to support plenary power, right? So there's a more nuanced issue there, but you need that, frankly. And you also need a recognition that the federal government has taken on obligations to Native people, right? And so right now in federal Indian law, that's expressed as the trust doctrine. But the trust doctrine is hierarchical in nature, right? That it depends upon this notion or idea that there are groups of people who are incapable of making decisions for themselves. And there are groups of people who are capable of making decisions for those who are incapable of making decisions for themselves. And so that idea has served us to some extent, but perhaps also, well, not perhaps, but definitely cements a hierarchical structure that, again, does not allow for Native peoples to escape this perception or understanding of being lesser than, the quote unquote dominant culture. Right. So what you need is you need a rebalancing of a relationship that recognizes and understands that the United States has taken on obligations to Native America. But that has to be more familial in nature, more like an older brother, younger brother type of situation, much like you argued in Linking Arms Together. That book was foundational, certainly to this part of the argument and the book as a whole, right? Acknowledging and understanding that we should think about that relationship much differently as well, too. So if you have those three things, I think that it is possible that we can rebalance this relationship in a way that makes a lot more sense and that rids us of the specter of plenary power that hangs over the heads of Native America that we are constantly frightened and worried about.
So you do point to international human rights law and its values and norms, and UNDRIP, the UN Declaration Against Indigenous Peoples. Maybe talk a little bit more about the role of the contemporary global Indigenous human rights movement to the development of federal Indian law. Does it have anything to add? How do you get it added? Is it something Native peoples here in this country should be paying attention to and using? Because it seems to me that that's sort of the glide path for the type of reform you're talking about.
I think it very much fits, right? I think that the whole thrust, as far as I can tell, of the Indigenous human rights regime on the global scale is about reinstituting this notion or idea of consent, right? And this idea of a much more reciprocal rather than hierarchical relationship. And so things like the UN Declaration, right, call for free, prior, informed consent. And that's at the center of the analysis. So that this methodology that I am suggesting that we adopt when re-articulating what this relationship is very much falls in line with those international human rights principles. And what's great about it is that because since it also still has this hook to the Constitution, right, we can pull it into a domestic sphere, in a domestic realm, again, following your book, Like a Loaded Weapon, which called for the domestication of these international law principles. And so I think this is another way to potentially do that.
So I see some aspiring young scholars and younger faculty members, much younger than I, and talk about the process of writing a book. How do you, when do you do it? How do you find time to do it? And just a little bit about your own creative process, because I think the book is very creative in a number of different ways. And so I was very interested about how you sustain that passion, that sense of humor. Where do you draw your inspiration from?
Well, there's a lot of answers to that question. One of the things is it was just the right moment to do this. Okay. And I was lucky that I got a fellowship at the National Humanities Center, which gave me a little bit of time and space to do it. That was one thing. But I was also in a place where it made sense to both tackle this question that I've had for decades, right? When did this become constitutional? And it has been a question ever since I read Kagama and read the later cases. It's like, wait a minute, something's going on here. So I finally have the moment to address this question. And it was on fellowship and it was time to do it. There's also time to write something different. Okay. To write something a little bit different in terms of, again, perhaps inspiration, not perhaps, definitely inspiration from the Vampires Anonymous article, where you talk a lot about doing what you are passionate about, right? Not getting so wrapped up in the what the academy seemingly asks of you, but doing what it is that you need and want to do and why you got into this profession in the first place. So that was part of it as well, too. But then as soon as I realized, hey, the Supreme Court is telling the worst trickster story ever told, then I knew that the book itself had to operate a little bit differently than most of your traditional academic texts. If this was going to be the lens of analysis, it could not function as just another book about the law. But then to also answer another part of your question, when it comes to writing a book, what I would suggest to anybody, and I have suggested this to many people, is it is overwhelming to sit down and say you're going to write a book. It is too much to sit there in front of the computer and say you're going to write a book. Okay. What you have to do is you have to plan out a little bit about what it is that you think is going to happen in the book, and some idea of what the chapters are going to be and how they line up into an argument. You have to do a little bit of work in that nature. But when you sit down to actually write the book, the thing that I did that was helpful for me was I set a daily goal, right? I said, I'm going to write 2 pages every day. And what that daily goal did for me, right, is 2 things, 2 very important things. One is it held me accountable, right? It said that this is something that I have to do towards the progression of this thing that I want to accomplish. And so then you don't get paralyzed necessarily by, oh, I got to write this book and I've got all these things going on. You can write 2 pages. Anybody can write, or 500 words, or 1 page, or 1,000, whatever the goal is, right? That is something you can accomplish in a day, though, right? If you set that goal, that is something you can accomplish in a day. And there would be days that I would write 6 pages, right? Which was fine, which was great. But then the next day I still had to write 2 pages. That didn't give me 2 days off, right? I still had to write 2 pages the next day. So the one thing that it did was it held me accountable. The second thing that it did, which I don't think I realized at first, but which is vitally important, was it gave me permission to stop. And that was critical as well too, because there were times before I would do things like set this daily goal. I'd write maybe 10 pages a day and it would still not feel like enough, right? It would just still be exceptionally overwhelming. And look, we all still have to go grocery shopping. We all still got to wash the clothes. We all still got to put the kids to bed or whatever the deal is, right? So also having permission to stop and live the rest of your life was able to allow me to keep a certain sense of balance and not let this thing overwhelm me.
So who would you say is the ideal reader of your book? Who did you write the book for?
Gorsuch.
Next question. You did that very well.
No, what I'll say is I very much, before coming back to the law school, say, I spent the last 10 years or so at the University of North Carolina teaching mostly undergrads. And that's why I wrote a textbook for a non-legal audience, right? It was because I needed a something to use. Case books are great, but they are meant for this audience, okay? And so when I was writing the book, I wanted it to be read in a lot of spaces. Certainly Gorsuch, if he gets his hands on it, but also I want it to be in every single intro to Indian studies class that there is, right? Here's something that helps to explain where we are in the law, that you don't need a big fancy legal education to have. But I also wanted it to be the text that perhaps students might take back to their families and communities and say, you can read this, right? This is what I'm working for, this is the ideas and issues that are at the heart of why I'm getting this education. And so I hope, and it was certainly written with this intention, that it could be read by anybody, and that anybody could understand what the state of the law was without having to have poured through a million different case books and having to figure out how to Iraq, or is that what you use here? Okay.
Iraq.
Yeah, whatever rack you use. Okay. All right. That you don't necessarily need that to understand what's happening in the book. And so my sincere hope is that this finds a really wide audience, both in the academy, but elsewhere.
What's your next book project?
So right now I am working with at least one student who's in the room on what I intend will be a website that lists every Supreme Court Indian law case. Okay. And not only lists that, but also lists the justices and how they voted in those cases. And I think that would be a resource that would be very valuable to lots of folks, certainly in the legal academy, but historians, right, other folks in different parts of the university. So once we get that together, I think that there are lots of opportunities for scholarship based on that. And what I hope to do with it personally is that I'd like to write a series of articles or perhaps chapters for a book called The Indian Law Legacy of This Justice or That Justice. Because as I was going through the cases for this particular book, I noticed some patterns, right? I noticed some things. I said, well, boy, I'd really like to look more into that. So, for example, Justice Willard Vandevanter somehow becomes the expert on Indian liquor cases in the early 20th century, right? And he does something interesting that I think we should know more about. Or most of these guys you've never heard of them. A guy from the mid-50s who you never heard of, who I think is the one who really gave us the language of trust that we use nowadays in the field. And we should maybe take some time to think about what some of the jurisprudence of these people is for the field and to the field, and give that some consideration. Place the field in a larger historical context.
Well, you've honored me today by citing several of my books. So what questions you want to ask me?
Why didn't you blurb it? No, that is, I was not anticipating that one, other than, do you see this as a potentially viable path?
Yes, and again, that's sort of why it's waited till the end to throw in UNDRIP, and I see a number of my students here. And they know sort of the angle of vision that I take on reform of federal Indian law is through international human rights discourse. So, for example, we talk about the duty of trust, and you're right, it is highly patriarchal, an artifact of colonization. But if you look at the duty of trust from the perspective of Indigenous human rights, all states have a duty to protect your basic human rights, and particularly for particularly vulnerable peoples, such as Indigenous people, such as women, such as children, such as immigrants. There's that basic duty to protect. And so once you have the international standards articulated that governments agree to, and the US has signed on to the major human rights covenants, they finally came around and said, yes, we should have voted yes on UNDRIP. Once you have that foundation and that recognition by your state, then that becomes a pathway to reform federal Indian law according to that discourse. And I think that discourse is much different from the ones that you're doing an incredible job of deconstructing and again using that angle of vision of native knowledge. All right. Well, let's open it up. Is it time? Is it a good time to start questions? Sure. We have till what? 1:15 or something?
We have till 1:15.
Okay. Questions for Keith?
Did I answer it all?
Yeah.
Keith, really enjoyed this talk. Enjoyed talking to you about outside of this little conversation too. I'm wondering if you thought about how the Trickster story, the Trickster lens, might illuminate other applications of the plenary power doctrine to immigration or to U.S. territories.
Well, I think they're all in the same vein. So chapter 1 is establishing the mystery, right? Which is how did plenary power become constitutional? And chapter 2 is titled The Conspiracy because it demonstrates how plenary power in Indian law is something that drives and is also further developed in these other areas of law. So the Northern idea of plenary power doesn't just exist in this space, it doesn't just operate in this space, but it is a creature of its moment in history in which the federal government is deciding what it's going to do with non-white people as it's increasing its own territorial expansion and imperialist desires. So I don't spend all of the time in this book talking about those other areas, But I hope that I do illuminate that this is something that very much exists and comes out in the same moment and is of the same motivation, as it were, as plenary power in Indian law. And other folks have written more extensively about the interweaving of the doctrine in these three areas of law, and I lean on that scholarship. But hopefully the book does illuminate that this is the same thing happening in these other spaces. Other questions?
I know there's a lot of intersection, especially in Supreme Court cases between plenary power and the trust relationship. I think the courts have sort of tricked everyone into believing that they have plenary power because of the trust relationship. So I'm wondering what you suggest in your book or now, what happens to the trust relationship if we get rid of plenary power? How does that play out?
Well, it's, as I noted, chapter 5 is suggests that we need three things, right? That we need consent to be at the center, that we need a constitutional hook, but that we also need to recognize that the United States has taken on an obligation to Native people. And that obligation right now, as we think about it in this trust responsibility, is hierarchical in nature and does in many ways operate in the way that we know, which is that we've got this trust responsibility that helps to support this massive federal authority over Native peoples called plenary power. But if we think about that relationship differently, right? If we think about it more in the line of the international realm that Professor Williams has articulated and that he's done significant work in, and we think about it less as this hierarchical structure, but more as a familial structure, right? The older sibling and the older sibling and younger sibling, right? Then we can understand what that relationship should be in the context of how to think about a way to understand federal engagement with Native peoples that is not plenary power, that is much more reasonable and based on this notion of consent.
It is interesting. I always ask my students, name any other area in the Constitution where Congress is given plenary power. And there's only two other areas: immigration and the power to declare war. Those are the three areas. And when you think about it, and it kind of gives you a sense that, as you said, the founders were dealing in their moment. And I think the law opinion by Breyer recognizes that, but doesn't know what to do with it. And I think that's a problem. We don't know what to do with these archaic, racist, historical doctrines that underlie our Indian law. And we're looking for pathways forward. And I think that's where your book offers important pathways, particularly through Native knowledge. And I think a lot of the work that's been done here at the U of A by the Native Nations Institute, for example, it focuses on the importance of cultural match, of making sure that the work you're doing and in building your rights to self-determination and building your community matches with the way that you think about the world as a Native person. And so, again, I know you were here and I did some work with the nation building model. Are familiar with that. So it is interesting to see these various Arizona influences coming together in your work, and very much appreciate it. So, yeah.
It was a pivotal year. It was an absolutely pivotal year for myself personally, and obviously for my career as well too. So, come get your LLM.
I'm wondering, do you give Justice Gorsuch enough hooks to begin to take steps in this direction? Is there a path rather than a choice? Essentially recognize the complex history of the plenary power and reject it for peoples, or is there an alternate set of arguments, or is there an area or a particular topic in which you think that your argument might be planted or grow? I'm just wondering if there's a path as opposed to an ultimate switch.
Well, so I somewhat, although not completely facetiously, said that Gorsuch was the audience, and he clearly, if he happens to read the book, that would be great as well too. But the book is also very much directed, and I should have said this in the answer to Professor Williams' question. The book is also very much directed at this audience as well too, the people who are going to be lawyers, right, and the people who are going to work in this area, who are going to feel compelled to continue telling this worst trickster story ever told about how the federal government has plenary power under the Commerce Clause. And my argument is that this is another way to think about what that relationship should be, and another way to argue what that relationship should be that undoes the knots you have to tie yourself into to believe that the Commerce Clause is the source of this overarching thing that is essentially unlimited. And I recognize, right, that lawyers have clients and clients want to win their cases and don't want to necessarily be the guinea pig for novel legal theories, right? But that's also why we get to argue in the alternative, right? So there are ways or there are opportunities to begin interjecting this, not just at the Supreme Court level, right? Because if the goal was to just change the minds of the Supreme Court, that would be ambitious, okay? And the book is hopefully that ambitious, but it's also speaking to the folks on the ground who have to try to figure out how to do this in courts, right? And begin digging up this thing from the roots, because I suspect it's not just going to happen from high above, but that it's going to, if it takes root the way that I want it to, it's going to start with, again, the people in this room who are hopefully convinced by the argument and then start making the arguments themselves in various court systems.
And just following up on that, there is one justice who agrees with you that we need to get rid of the plenary power doctrine, and that's Justice Thomas.
Yes.
And you do address it in the book, but I wonder if you just spin that out a little bit.
He's an interesting character, right? And I don't have any intention of trying to change anybody's minds about Justice Thomas as a jurist or as a person or however else you might think about it. But he is the only justice on the court that I see and that I have seen who's called this out for what it is, right? And in Laura, he starts in Laura, right? So we're 20 years of this from Justice Thomas. He says, look, I've read the Constitution. I've read the Commerce Clause. There's nothing about the Commerce Clause that says that the federal government has plenary power. Now, of course, he tempers that by saying, yeah, I'm not exactly sure about the source of sovereignty for tribal nations as well, too. So you never know exactly where he would fall, although perhaps some of us have our suspicions if we were to disrupt the notion or idea of plenary power, if we were to do what he's been calling for us to do. But regardless of however else you may feel about him in other contexts, right? He's the one who has been saying for 20 years, hey, look, the emperor has no clothes. And so I take that seriously, right? And I think that whatever agreements or disagreements I might have with him in other contexts, it's worth taking that seriously, right? And I think it speaks to the power of this worst trickster story ever told, because whatever you think about this or that particular justice, they're not dumb people, okay? They're not dumb. And so they also know that this doesn't add up. I believe with all of my heart and soul that they know that the story they're telling is not accurate or inaccurate, that it doesn't really fit into any sort of model that they understand. I think part of the problem is that they don't know how to figure out how to crawl out of the loop that they find themselves in. And so hopefully this is a way to help them and to help folks help them as they work their way through their own legal career, find their way out of this loop.
So, as you're speaking, I was thinking of Justice Thomas, and I could see from his perspective, there might not be any need for any sort of trust relationship or protection. And that I'm thinking of another trickster, like the motivation behind like the cases trying to undermine ICWA and cases of like the corporation, privatization, sort of like we don't need the federal government because we want to privatize things, and that can lead to unhinged corporate greed and discrimination. And I was wondering, like, who's that other trickster out there that we have to fear? And how can we prevent that?
Well, I would say that that's why there are three parts to what I'm recommending. One is acknowledging that there is a relationship here, that the United States does have to, right? That we're not giving up on that reciprocal relationship. That has to be fundamental. Otherwise, we could fall into a situation where, well, we should just treat Native peoples as citizens like everybody else, and sovereignty doesn't really fit into our model. Well, no, that's not how the history has gone. That's not the promises that have been made. We need to figure out how to make sure that those obligations continue to be honored. But I also think your question speaks to what I think is part of the problem as well, too, is that I think folks in this field are terrified by the idea of giving up plenary power. So we know that there have been articles, not from Professor Williams, but in response to Professor Williams, about how we need to learn to live with this. And I'm not so sure that we do. And I think a big part of the motivation for a lot of folks, understandably, by the way, is a fear of the unknown. What happens if we do replace this thing that I've spent my life as a scholar studying and writing about and trying to understand? And for me, the issue is am I really going to use this analogy? The fruit of the poisonous tree, right? Are we ever going to get anything that's better if we continue with this foundation in which plenary power is rooted in racism, but now gets to hide behind the Constitution?
And of course, that echoes Justice Jackson's famous dissent, that once the court has embedded racism into a constitutional principle, it's there as precedent, like a loaded weapon ready to be fired off by the next judge. I think that's the strongest argument against the plenary power doctrine. And I do think you're right, where scholars, practitioners, tribal leaders are all, searching for, what comes in place of that can perpetuate and guarantee our cultural survival, our identity, down to 7 generations. And I think that's the challenge for Native people in this society and the United States as well. If any country in the world can create the conditions in which the indigenous tribal peoples who were colonized and basically subjected to genocide can revive and rebuild their cultures, as we're talking about the work that's done here, it should be the United States. And I think your book calls us to that moral challenge. And when Mark asked that question about Gorsuch, I was thinking, well, what would be wrong if a Supreme Court justice jumped up and right after argument said, damn it, a treaty is a solemn moral obligation, you all better keep it, and just shame them into doing the right thing. So, and I think he could be the guy who do that, maybe. So,
Right, he leans in that direction.
Thank you. Looking forward to reading your book. Looking forward to getting a copy. Looking forward to having you sign it. We've talked about Congress and we've talked about the Supreme Court, but there's the executive branch. And treaty making era ended in 1871. And in the past, you've talked about retreating, this idea of retreating. And one way of doing that, to some extent, without going through the intricacies and the pitfalls of treaty making, treaty making with Congress, is through tribal consultation policies with the executive branch. The executive branch, for just about all the agencies, they have consultation policies that they never follow. Yet tribes themselves, the native nations themselves, can undertake to put their own consultation policies in place. When you're talking about consent, if you want to talk to us, if you want to go ahead and ask us our opinion, free, prior, informed consent, these are the terms and conditions that we will respect. And the Chippewa Temps, an Anishinaabe nation, that's fantastic. They talk about their neighbors, they talk about their history within the consultation policies, even before they get to the guiding principles of how you're supposed to talk to us. So do you see that the executive branch, through a process of almost like retreating or executive orders, after 1871, the reservations were created by executive order, like President Grant. Do you cover any of that within the book, or is that your next book?
Why do you keep asking about the next one? Hard enough to write this one, huh?
Did I get a question in there?
No, you asked a very useful question, which is in one respect, toward the end of the book, I asked the question, why did I even bother writing this, right? Because in many respects, we are already close to what it is that I'm calling for, right? That you think about environmental legislation and that there's an opportunity for tribes to be treated like states, right? And that you think about cooperative agreements, right? That tribes and states and even the federal government have realized that long, lengthy litigation in which only one side wins doesn't engender a lot of goodwill. So in many respects, we are already at least headed down the path that I'm asking us to continue moving down toward. And so the question becomes then, well, then why did you bother writing this book if we're already heading that in this direction? And the answer is because the Supreme Court keeps telling the worst trickster story ever told. Okay. And so that what I'm advocating for is actually not that radical of a change from a lot of the practice that we're engaged in and that we continue to be engaged in with things like cooperative agreements and with recognizing that litigation is maybe not the best way to figure out the parameters of this relationship. And so Congress has been, in many respects, headed toward that direction. We see the opening up of criminal jurisdiction for tribal nations and tribal lands. That Congress is that way, executive is headed that direction. Problem is that Supreme Court will not let go of this notion or idea of plenary power as rooted in the Constitution. And we're never going to be able to effectuate to the fullest extent the positive directions that we've headed towards without rooting out this idea in the law through the courts.
Well, thank you, Teresa, for putting us on. Thank you, the audience, and thank you, Keith, and congratulations on the book.